First of all, a hearty greeting for all those who are watching and listening to this video. Myself, Sidra Choudhry, a young law student interning at ubAdvocate. My topic is nuisance, essentials, kinds and defenses in law of torts. First, we will look at the meaning of the nuisance. The word nuisance is derived from the French word nuire, which means to hurt or to annoy. Annoyance can be from a variety of intangible things such as sight, smell, noise, etc. In other words, a nuisance is an act of indirect interference to the enjoyment of one's property by causing any type of discomfort. The law of torts recognizes nuisance as an offense for which the aggrieved party can approach the court for relief. Now we will look at the definitions which were given by various jurists and scholars. Stephen defined nuisance to be anything done to the hurt or annoyance to the lands, tenements of another and not amounting to trespass. Birmingham says that nuisance is an unlawful interference with a person's use and enjoyment of land or of some right over or in connection with it. Now we will know about the essential elements of nuisance. To constitute nuisance as an actionable tort, it is essential that there exist a wrongful act. Such act have resulted in the interference with the use or enjoyment of land or some right over or in connection with the land. Because of the interference, there must be damages or loss of inconvenience or annoyance caused to another. To understand it better, we will refer to the important case law. Ushaben versus Bhagyalakshmi Chitra Mandir. In this case, appellant sued the respondent and asked for permanent injunction to restrain them for exhibition of the film Jai Santoshi Ma. It was contended that the exhibition of the film was nuisance because the plaintiff's religious feelings were hurt as goddesses Saraswati, Lakshmi and Parvati were portrayed as jealous women and were ridiculed in the film. It was held that hurting religious feelings was not an actionable wrong. Moreover, the plaintiffs were free and not compelled to watch the movie. Now, we will discuss about the kinds of nuisance. Nuisance is of two kinds, that is, public nuisance and private nuisance. So, first we will discuss about public nuisance. It is defined under section 348 of the General Clauses Act 1897 as public nuisance is an unreasonable, unwarranted or unlawful interference with the right common to the general public. In simple, we can say a public nuisance affects the society and the people living in it at large or some considerable portion of the society, and it affects the right which the members of the society might enjoy over the property. Section 268 of Indian Penal Code also defines a public nuisance as an act or illegal omission which causes any common injury, damage or annoyance to the people in general who dwell or occupy the property. Let's refer to the case laws for better understanding. First, Soletu versus D held 1851. The plaintiff resided in a house next to Roman Catholic chapel of which the defendant was the priest, and the chapel bell was rung at all hours of the day and the night. It was held that the ringing was a public nuisance and the plaintiff was held entitled to an injunction. Let's look at another case. Attorney General versus PYA Queries 1957. In this case, it was held that the nuisance from vibration causing personal discomfort was sufficiently widespread to amount to a public nuisance, and that injunction was rightly against the quarry owners, restraining them from carrying on their operations. Now, second kind of nuisance is private nuisance. Private nuisance is that kind of nuisance in which a person's use or enjoyment of his property is ruined by another, Unlike public nuisance, in private nuisance, an individual's usage or enjoyment of property is ruined as distinguished from the public or society at large. Let's refer to a case law of private nuisance to understand it better. Radhe Shyam versus Gur Prasad. In this case, Mr. Prasad and another filed a case against Mr. Sham and five other individuals for permanent injunction restraining the defendant from installing and running a flour mill in the premises occupied by the defendant. Mr. Prasad filed another suit against Mr. Sham. The plaintiff had alleged that the mill was causing a lot of noise, which in turn was affecting the health of the plaintiff. It was held that by running a flour mill in a residential area, the defendant was causing a noise to the plaintiff and affecting its health. Now let's look at what are the defenses to nuisance. So there are two defenses. First, prescription. A prescription is a title acquired by use and time and is allowed by law. A person claims any property because his ancestors have had the possession of it for the period prescribed by the law. This is mentioned under Section 26 of the Limitation Act, Section 15 of the Easements Act. If a nuisance has been peacefully and openly been going on without any kind of interruption for 20 years, then the defense of prescription available to the party. Second defense is statutory authority, where a statute backs a particular act or the use of land in a particular way. All remedies, whether by way of action, are taken away. Statutory authority may be either absolute or conditional. In case of absolute authority, the statute allows the act notwithstanding the fact that it must necessarily cause a nuisance or any other form of injury. In case of conditional authority, the state allows the act to be done only if it can be without causing nuisance or any other form of injury, and thus it calls for the exercise of due care and caution and due regards for private rights. In the last, I would like to conclude by saying that the law of nuisance is mostly uncodified. Over the years, it has developed through the interpretation of different laws and precedents delivered by the judiciary in its various judgments. The decision in cases concerning nuisance is deliverable on a case to case basis. Thank you.